So today we're going to talk about PBMs and some action that's taking place at the state level, in particular in the state of Ohio. And Shawn Busken is here from the Ohio Attorney General's office to talk to us about the issue in general, but also about the lawsuit that they're working on. If you are in a place sitting at a computer to turn on your video at some point, that'd be great, just so Shawn doesn't feel like he's talking at just me. If you're driving or doing something else, totally understand, and please get to where you need to be safely. But just for those that are sitting at their desk. So Shawn, I would love if you could just introduce yourself and then hand it over to you. We are going to have some time for Q&A, so please be thinking about your questions, either about the specific suit or about the PBM issue in general, but really look forward to diving into this. So Shawn, hand it over to you.
Well, thank you, Josh. Thank you for having me. And it's great to be here and have this opportunity to talk about what we're doing here in Ohio. Recognize some of the names here. So anyway, I am the Deputy First Assistant here at the Attorney General's office and the Director of Outside Counsel. I've been working on PBM issues for, probably about 6-7 years, going back to my time at the Auditor's office when current AG Dave Yost was then Auditor of State for the state of Ohio. And we did the first of its kind audit of PBMs. I think it was the first that had been done anywhere in the United States. And that document's still out there. It's fascinating to read through and look at. But that was kind of how we got our start. And then we continued with several PBM lawsuits here in the AG's office. So, and I'm happy to jump into those when you give me the go-ahead.
Yeah, go right ahead. I think it would be great to get a little bit of history of the issue in Ohio and then talk a little bit about the case. Shawn.
Okay, sure. So starting with that audit, I believe that would have been probably 2017 or 2018. We did that. And back then, spread pricing was the phenomenon PBMs were using to, charge the state more than they were reimbursing pharmacies. And after what we uncovered, showing the various spreads that were used by CVS Caremark or Optum RX, prohibitions were put into law in Ohio against spread pricing, as they were in many states. However, we cautioned at that time that PBMs would probably just shift to a different model and continue to extract value in the form of administrative fees and such, since spread pricing was outlawed, and that, sure enough, that happened. We've all seen that. So spread pricing kind of went away, but the PBM stayed and continued to charge what they called fees. So when we came here to the AG's office, we inherited several lawsuits that our predecessor, Mike DeWine, had filed against Optum on behalf of BWC, against Optum on behalf of DAS. And then we also pursued a new lawsuit, DAS's Department of Administrative Services, BWC's Bureau of Workers' Compensation. So those were both against Optum. We also had a Highway Patrol Retirement System lawsuit against Express Scripts, which is still going. And then we initiated a lawsuit against Centene, which was associated with the Buckeye Health Plan here, for essentially double billing. Department of Medicaid just administers Medicaid services through various MCOs throughout the state. So, and as you may know, we settled Centene a couple of years ago. That was $88 million. And then we settled Optum for 15, and the other Optum, that was BWC, and then the other Optum for 7 or 8 million. So in total, we've recovered over $100 million from PBMs on behalf of the state of Ohio. and then most recently filed our antitrust suit against Express Scripts, Cigna, Humana, Ascent, and others. So that's kind of a history of how we got here. But I think that the next step would be to go deeper into our most recent suit.
Yeah, can you lay out what are the general arguments in the suit against Express Scripts?
Sure.
And
sure.
I mean, I think it's as I was reading through the case, I feel like for those that are less familiar with the industry, there is some very educational things that you guys lay out, probably helping the court try to understand some of those issues too. But I'd love if you could kind of just talk about how you've structured the lawsuit and some of the facts that you're trying to put on the table.
Absolutely. And yes, I would recommend that to anyone here. If you want to just kind of understand the big picture, take a step back and see how this industry has evolved. The complaint does an excellent job of laying that all out, just in painstaking detail, but also in a readable way. So if you're interested in this, please read the complaint. The complaint begins by saying PBMs are a solution that became the problem. And anyone who's dealt with the history of this will understand what that means. They were a response to rising pharmaceutical prices, essentially, and to pool insurance so that they could get lower prices on drugs, which was probably a good thing at the outset. However, in our lawsuit, essentially, we started by looking at insulin, and we're all familiar with the rising cost of insulin. We all have diabetics in our families, no diabetics. We know that generic insulin prices have skyrocketed over the past 10, 15 years. And then the drug is not much different than it was back then. So synthetic insulin. And it's controlled by relatively few companies. There's 3 companies that control the supply of insulin. As we talk to some of those companies, various players in the industry, we talked to Kroger, we talked to Meijer, to Walmart. We also talked to the suppliers of the manufacturers of those drugs. What became clear is that the PBMs really are driving up the cost of those drugs, and they do it in this way. They control formulary, as we all know, just the list of drugs that are covered under your particular plan. And they control whether a drug will be available to you under your plan. And everyone wants to be on the formulary. That's extremely powerful. The PBMs refer to the PBM by covered lives because they control the access of drugs to covered lives. And so they kind of hold a gun to the manufacturer's head and say, we want greater and greater rebates. Now, they don't refer to them as rebates in their contracts. They refer to them as administrative fees, or they give them various names. But they are. I mean, they actually, in their contracts, refer to them as, quote, value, extracting value from the manufacturers. But they just keep driving up those rebates. Now, what's really interesting is that all of the PBMs in the past 5 years have created the subsidiary GPOs, group purchasing organizations. That's what GPO stands for, which act as, quote, rebate aggregators. So they've kind of spun off the rebate side of the PBM business so as to say, the rebate business is on one side and the formulary control is on the other. However, we know that they are controlled by the same entity. One of the most prominent GPO rebate aggregators is a company called Ascent, and it's a subsidiary of ESI, which is a subsidiary of Evernorth, which is a subsidiary of Cigna. So there's a lot of entities involved here. But Ascent is kind of the key to our antitrust lawsuit, because Ascent, acting as a quote rebate aggregator, GPO, they are the ones that have contracts with the manufacturer. So if I'm Eli Lilly and I'm manufacturing insulin, and I want my insulin, my products to go to the most people possible, I have to contract with Ascent to obtain access to quote covered lives. And we're talking hundreds of millions of covered lives. And so they do. And so Ascent contracts with manufacturers and say, if you want access to these lives, pay these fees, all sorts of special fees. And those rebates are supposed to pass through back to the insurer, the MCOs, but in fact do not. A lot of times they go back to the PBM. It's a business. I mean, they take their cut in the form of those fees. And so you have essentially extortion of the manufacturers to continue to extract more and more value from the chain, from the value that's for the cost of these drugs. So, which drives the drugs up. What's really interesting is that during the Trump administration, there was an effort to crack down on this. There is an anti-kickback statute. However, PBMs have taken advantage of a safe harbor in the anti-kickback statute, and Trump was trying to repeal the safe harbor to the anti-kickback such that they would no longer be able to do this. And although that was never passed, the GPOs were a reaction to that potentially happening. And so it was a way for them to avoid the potential legislation that would have removed them from the safe harbor of the anti-kickback statute, because this sounds like kickbacks, because it is. And so that's where Ascent and all of these GPOs came from. And if you look at the different PBMs, whether it be CVS, Caremark, or Optum Rx, they all have their own GPO. Robert Fine has a really good chart that he updates regularly that shows the consolidation of the industry, and then it shows all the different entities and the healthcare company, and they own the PBM, and the PBM owns the GPO, and it just goes down this. And anyway, so I'm sure Josh can supply you with that chart after this, and it's in our complaint. So what we found was that Ascent, acting as this rebate aggregator, was working with multiple PBMs, and that's where the antitrust problem comes in. So in our view, that is collusive behavior that's violated of the Sherman Act at the federal level, but also the Valentine Act, which is our state level kind of, it's not the equivalent. The causes of action are similar, but Sherman Act is one thing under federal law, Valentine Act under state law. And we sued in state court, and we believe this belongs in state court. So we believe there was collusive behavior by Ascent as a subsidiary of ESI among multiple PBMs, Humana being one of them, and their PBM, as well as Blue Cross and Blue Shield and their PBM. So they're essentially sharing this data and using the shared data across PBMs to extort the manufacturers and drive the price of drugs up. That's what we found. There's also a phenomenon called clawbacks that we found, and this goes to the other end of the value chain, I suppose, which at the pharmacy level, we've found that many PBMs are clawing back a portion what they pay the pharmacy for these drugs, and there's quite a power differential such that they're able to extract that from them. So they're dinging folks on the manufacturer side, and then also on the pharmacy side, and hurting that end of the business. So that's also in our complaint. You can read more about clawbacks and what they are in there. So sorry, I know that was a lot, and it's a highly technical world that this is. It's a Rube Goldberg puzzle when you look at it, but it's also the reason why our drugs are so expensive.
Great, thanks, Shawn. So you guys can be thinking about your questions. You can feel free to raise your hands in a second here. Just to kick off, I thought it was interesting. Further complication here. Ascend is in Switzerland, correct?
That is correct. Yeah, somewhat odd that they would be formed in Switzerland. Yeah.
So I wonder, just to start the conversation off here, Shawn, can you talk to us about talking to other attorney general's offices in terms of as those that have expressed interest or just to learn more? Do you feel like this translates well into potentially other states with the laws that they have on the book? Not to say that you need to be an expert on every other state's anti-competitive laws, but can you give me a sense for how you feel? Do you feel like Ohio's laws are uniquely positioned to bring a suit like this, or do you think other states would have similar ability to bring cases?
Right. Yeah, most states have a state equivalent antitrust law that they can bring these state claims. So we put together a multidisciplinary group with our consumer protection section, antitrust, health and human services, kind of looking at PBMs from all those different angles. There's even what's called a civil RICO statute that has to deal with fraudulent behavior that crosses state lines. We took a look at that as well. And in the end, we ended up with the antitrust theory that we filed. But we looked at, could we come at this from a consumer angle? Could we come at it from a contract angle? Our other PBM lawsuits were just simple contract breach matters. The Centene, Optum, those are all just contract disputes, and we won. So yeah, you kind of have to look at where you want to come at it. Other states on insulin and PBMs have some other states have chosen to go after both manufacturers and PBMs under different theories. And so in our case, we saw the antitrust behavior was, it's solely by the PBM. So that's why ours took that shape. But yeah, I know Florida, Texas, Louisiana, I think California has filed something. I want to say Mississippi. And what you see, there's the Harris County, Texas case. I think that's on insulin that survived on a partial motion for some summary judgment. Or no, it survived an MTD and then it went to partial summary judgment. Florida, and that was filed by a county in Texas. And then the Florida case, I can't remember the city, but a city in Florida filed on insulin with both the manufacturers and the PBMs. You can look up that lawsuit, or I can find it for you.
Okay, great. Matt?
Hey, Matt Mon, I'm with HRA, with Josh's group. First of all, thanks for taking your time today. So I'm in the pharma industry, and this issue has confounded me for so long. I still just wrapping my head around all the incentives. For the insurers that do not own a PBM, for the insurers that contract with a PBM, why don't they have more of an incentive to hold the PBMs accountable? Like, reducing the spread pricing, having it be pure pass through or just limiting the amount of spread pricing? Do you have any insight into why the insurers aren't basically holding them accountable and holding these PBMs to task?
It's a great question, and we wrestled with that, especially at the auditor's office, because we met with the various MCOs that have contracts with Department of Medicaid in Ohio. What I found was that most of them, I hate to say this, but don't care. The PBMs guarantee them a certain rate on these drugs, that the farm spend will not increase such and such a number. And if they can deliver that, then the insurance companies just they don't care. They throw up their hands and say, that they're doing what they said they would do under their contract. They're delivering this value proposition to us, and we don't need to delve any deeper into it than that. So that was the response I got, and sometimes also from the insureds, that they don't care either. Even when you bring this up to some of the pension systems, that they say, well, they're delivering on their contract what they said they would. But thankfully, a lot of insureds and insurers have moved to a pure pass-through. I mean, for instance, all of the rebate money goes back to the insured for workers' comp in the state of Ohio. They have that in their contract. And we have a single PBM in Ohio now that doesn't engage in these kinds of practices, as far as we know. So there has been movement to better actors in the industry, I would say. But still, these large PBMs, as you all know, control the vast amount of covered lives in the United States. So that's a great question, though.
Oh, thank you. That makes a lot of sense.
All right, raise your hand if you got other questions. Shawn, this is mostly policy folks on the call. We do have a couple lawyers, a couple folks who have been in the pharmaceutical world or are currently in it, though. From a policy standpoint, what's a way to bring greater attention to this issue? How do you get your attorney general interested? How do you get lawmakers interested? What studies could policy groups do, or data could they try to gather to try to bring some additional light in this space?
Yeah. At the legislative level, I can speak to Ohio, where they've already outlawed the spread pricing and other practices, and the industry has responded, and then our procurement process has responded in kind, and the normal actors are persona non grata for the Department of Medicaid or others, so they're not using them anymore. But as far as data goes, it is a highly technical world, and most of this data is covered by multiple confidentiality agreements. It's very hard to obtain the data that you need to run the numbers. But if you have a state client, they're entitled to that data, and that's why AG's offices are uniquely positioned to do something about this. If you have a cause of action through a state agency, as we did through workers' comp or DAS or Department of Medicaid, they're entitled to the data. They can request the data, and then you make your cause that they've essentially been overbilled by the PBM. I mean, that's what happened, that they didn't follow the contract that they said they would and give us the lowest possible prices. So that's one avenue. I think in order to get people interested in this, you have to have a hook, right? I mean, insulin is the hook, because it's real to us, and it's something everybody understands. But it's just a symptom of the disease. That's all insulin is. And our lawsuit was trying to get at the disease here, the root problem. Insulin is just an indicator of what's going on with thousands of other drugs. And we see this with cancer therapeutics or biosimilars to Humira. You've probably read about that. So it's not just insulin, it's with a lot of other drugs. There's a whole specialty pharmacy side to this where most of these PBMs have a specialty pharmacy unit. And when we did our audit, we found that the spreads were really, really high in specialty farm. So I think you need to look at the drugs where it's really impacting people on the ground. And insulin is just one of those, but there are many. And I think that's something that would garner the attention of public officials. It should, because it affects their constituents.
Right.
Yeah. So Shawn, going back to kind of your auditor days, you released a report in the PBM, and you had some people in the Ohio legislature, bipartisan, really diving deep in the issue. How helpful has been kind of the legislative oversight, that the legislature engaged on that issue? Did you guys continue to kind of work with them, both from either the lawsuit capacity or time in auditor, to have legislatures, having a lot of hearings and moving legislation on this?
Right. We did. I mean, when there was a lot of attention paid to this in 2018, and legislation was passed, and there is a Medicaid oversight committee that we testified at, put our audit report into the record, and that audit, was just cited this week, I think, and in some papers on this at the congressional level. So, there hasn't been much legislation since then because the state agencies have chosen a single PBM to administer, and one that is more transparent about pricing, and it's not one of the ones that we're suing or have settled with. Although I think Centene did have a bid in on the single PBM, but obviously they weren't chosen. So yeah, I don't see a whole lot of new legislation coming about at present. At the congressional level, there's been a ton of hearings in both the Senate and in Congress. So they continue to pay close attention to this issue. Lena Khan and the FTC has put a lot of attention on PBMs, rightly so, and continues to investigate them. I think just last week issued an order of some kind to demand data from the PBMs. So the FTC is paying attention. We certainly appreciate that.
I would go a little further on that one, and then I would love to open it up if folks are working on this issue in their states or there have been activity. Would love to hear about that. To build on Ray's question, how much education have you needed to do on this, whether it's with the media or with state lawmakers? I know that you made a concerted effort in this complaint to try to make it accessible, but do you have any kind of things that you have learned through this process, whether it's getting the auditor, now AG, kind of up to speed on how to talk about this in public? What have you learned through that process as people try to talk about this more in the public?
Yeah, it is complex and hard to understand or to explain. I've been working on it for 7 years and still feel like I don't grasp everything and understand it. I'm a long way off. So the other factor you have to deal with, we had here in Columbus, we had a team at the Columbus Dispatch that was intensely interested in PBMs, and they won some awards for their investigative reporting on it. All those reporters are gone now. They've taken jobs elsewhere. They're gone. There's no one that cares about this issue really left at the newspaper level. And so what we've found is we really have to go national to talk about this, to garner interest and discussion. And the Wall Street Journal is actually really tuned in to this issue. They understand it. They ask the right questions. They talk about it. They're willing to write op-eds about it. And they have over the past several years. So I don't know if the Times or if the Post have delved into it the way the Wall Street Journal has, but so yeah, I would suggest oftentimes going national because the local press just isn't interested, or they don't understand the issue. They don't want to understand the issue. That being said, there is one local, it's called Cap Journal here, and they still have one of those guys from that initial team, and he does write about PBM issues every once in a while. But yeah, that's what I would suggest.